Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics relevant to people living in Utah. Today we're kind of completing this series about common estate planning fails. These are things that people do, whether with or without the advice of counsel, that really throw their estate plan out of whack, and it does not have the same result as intended. We might continue more of these in the future, but for now this is kind of the ones that we've seen the most of over the last few years. So this one today is leaving money to somebody who owes other people money. We've touched on this briefly, but we figured this one deserved a little bit of a second look. If you are leaving funds to a child, grandchild, or any other beneficiary who owes other people money significantly, and we're not talking like a mortgage or credit card debt or anything like that. We're talking like judgments against them, or federal tax liens, things that really are hard to get out of and could force your trust to take time to distribute things a little more quickly than you would like, whether because of market conditions or anything like that, and could really force the trustee's hand in distributing the funds to this beneficiary who is not going to see any benefit from those funds other than payment of debt. And we don't like that. That's not the way that people want their estates to be planned. They want their estates to have the greatest impact to those they love. One common thing we'll do is, let's say one of the children has a serious lien or judgment against them. What we'll often do, depending on the state and where the judgment is and how the law works in whatever jurisdiction they are, we will either leave those funds to their spouse or to their children directly. And so we kind of bypass the child that way, who is having these money problems. And we'd only transfer to the spouse if the spouse is very trusted, and if it's not going to be subject, if those funds aren't going to be subject to the debt by virtue of them being married, and that varies by state law. But then to the children, the money to the children is definitely going to be protected. So if we bypass that child and go straight to their children, or if they have no children, bypass that child and go to their siblings or other beneficiaries, that way we know at least that the funds are going to be used for something that's going to be beneficial to the family as a whole, rather than just paying off creditors. So if you have anyone that, whether currently as you're doing your estate plan, or is likely to in the future have some kind of judgment against them or tax lien or something like that, it's important to account for that in the estate plan and make sure that those funds aren't going directly to them, so that we can kind of bypass them and make sure that the family is taken care of. There are a few other things you can do as well that we won't really go into, but there are some more creative solutions to maximize the impact of those dollars while still trying to take care of those we love, but bypassing some of those other restrictions. So if you have any questions about that, or you're wondering how to take care of your estate in the right way to make sure that it isn't something that just falls apart when everything else in your life does, then feel free to give us a call at any time at 435-572-0807.